today's video, I'm going to discuss another important constitutional case of constitutional history of Pakistan, the Governor General reference case. And I'm going to discuss that how the famous doctrine of necessity originated in the history of Pakistan for the first time and how it was used by the federal court. So, as I have already discussed in Maulvi Tamizuddin Khan case, that federal court withheld that every law must receive the assent of Governor General in order to become a valid law, and unless there is assent of Governor General, law is invalid. It does not have any legal force, any binding force, because it is not a valid law. So when this decision came, there were almost 46 acts which did not have assent of Governor General, and Governor General issued an ordinance, emergency power ordinance, and he validated those laws by giving retrospective assent. And when this issue was put forward to the federal court in Yusuf Patel case, the federal court withheld that Governor General is not competent to give retrospective assent, and he is also not competent to work on constitutional matters. That is purely domain of the Constituent Assembly. So when this decision came, the Governor General issued or he summoned Constituent Convention, and he assumed with himself the powers to validate all those laws, and he referred certain questions to the federal court, and he said that those laws which are invalid, declared invalid in Maulvi Tamizuddin Khan case, they are valid until but subject to the decision of federal court in the reference which I have referred to the federal court. And when the reference was put forward before the federal court, initially there were two questions put before the federal court. First one was that what are the powers and responsibilities of the Governor General until the Constituent Convention does some necessary legislation. And the second question was put that whether there is any provision in the Constitution or any rule of law available using which the Governor General could validate those laws which were declared invalid by the federal court just because of lack of the Governor General's assent, unless the Constituent Convention decides the validation of such laws. Initially, these two questions were put forward to the federal court, but federal court itself suggested that the reference be enlarged, and the federal court, the federation added further questions upon the suggestion of the federal court, and two more questions were added, and these questions were that whether the Constituent Assembly was rightly dissolved in 1954, and another question that whether the Constituent Convention summoned by the Governor General, called by the Governor General, would have the same powers under Section 8 of Indian Independence Act 1947 which the Constituent Assembly had. So these questions were put forward to the federal court, and federal court answered these questions. Now let's discuss that what answers were given to these questions. As to first question, that what are the powers and responsibilities of the Governor General, the federal court withheld, said that it is too general question and it need not be answered. So federal court did not give any answer to the first question. And as to second question, as to next question, I will discuss that whether the Constituent Assembly was rightly dissolved or not. In this question, in this an answer to this question, Justice Munir gave a detailed opinion in which he discussed different aspects, and he said that looking into the scheme of Government of India Act 1935 and Indian Independence Act 1947, it is clear that Governor General, the power to dissolve the Constituent Assembly or legislature was taken back from the Governor General, which was the prerogative power of Crown, and Governor General did not have any power to dissolve the Constituent Assembly. But he said that again, looking into the scheme of these acts, it is very much clear that the Constituent Assembly was supposed to perform its function, its task of framing constitution within a reasonable and limited time. But after the passage of 7 years, the Constituent Assembly failed to give any constitution, failed to frame any constitution for the country, and rather it tried to take form of perpetual legislature. And Justice Munir said that when it tried to take form of perpetual legislature, it was totally contrary to the norms of democracy, and for the purposes contrary to the purposes for which the country was made. Because if the legislature become perpetual, the right of people to choose the representative of their own choice will be curtailed, and people will have no right to choose the representatives of their own choice. So that was contrary to the norms of democracy, and the federal and the Constituent Assembly, instead of framing constitution within a limited time, it tried to take form of perpetual legislature, and the prerogative power which were taken back from the Governor General, they were not taken back permanently and not absolutely. They were prerogative powers, and they were only taken back up to the extent if the Constituent Assembly works in a reasonable manner and works and does its job as it is supposed to do. But when the Constituent Assembly failed to perform its task, then the power to dissolve and the prerogative power to dissolve was revived, and the Governor General was competent to dissolve the Constituent Assembly. Federal court further went into the detail of this answer, and they made a specific chart, and in which different name of different countries, and then the Constituent Assembly formed, date on which the Constituent Assembly of that country was formed, and then date on which the constitution came, and the time consumed by the Constituent Assembly of the country to make the constitution was mentioned, and there was a name of many countries, and the maximum time taken according to that list was 2 years and some months. Even India had made the constitution in 2 years and 10 months. And the federal court said that the Constituent Assembly of Pakistan had failed to perform its duty because 7 years had passed, and Constituent Assembly did not give any constitution to the country. So the power to dissolve the Constituent Assembly was vested in the Governor General, and it was revived because Governor General had to look that had to see that if the Constituent Assembly was not working, was not performing its task, it was taking the form of perpetual legislature, then Governor General was competent to dissolve the Constituent Assembly. The federal court further went into detail and said that the word rightly used in the question does not mean rightly in its literal sense, and rather it means that whether the Constituent Assembly was lawfully dissolved or dissolved under the Constitution, it does not mean the literal meaning of right. And federal court at the end held that the Constituent Assembly did not remain representative of the people of Pakistan as alleged by the Governor General while dissolving the Assembly. Secondly, the Constituent Assembly failed to perform its duty, failed to perform its function. And thirdly, the Constituent Assembly was passing the acts overlooking the mandatory requirement of taking assent of the Governor General. So anyways, federal court withheld that the resolution was right, and the Governor General had rightly dissolved the Constituent Assembly. Now let's come to next question, that whether the Constituent Convention would have the same powers under Section 8 of Indian Independence Act which the Constituent Assembly had under the Section 8 of Indian Independence Act. As to this question, the federal court withheld. Federal court said that when we said that it is prerogative power of the Governor General, prerogative power of the Crown exercised by the Governor General to dissolve the Constituent Assembly, it is also prerogative of the Governor General to resummon or call another Constituent Assembly, the Constituent Convention which has been called by the Governor General. Federal court further said that the Constituent Assembly, which was formed in 1947, that was not formed by a specific act of legislature or by any specific legislation. Rather, it was formed by the Governor General, and now too it has been formed by the Governor General. Just the difference is that in 1947, when the Constituent Assembly was formed, the Governor General was answerable to the Crown, British Crown, but at this stage he is not answerable to the Crown. But anyhow, it has been passed, it has been made by executive order, that is right, that is lawful, and the Constituent Convention has been rightly called. But federal court said that it will work, it will have the same powers as the Constituent Assembly had under Section 8 of Indian Independence Act, and all the powers which the Constituent Assembly had under Indian Independence Act, subject to following such certain conditions, and those conditions included that its name will not be Constituent Convention, rather it will be called Constituent Assembly, because the powers are to be exercised by the Constituent Assembly. Secondly, the Governor General will not have the power to dissolve just as he has called the Assembly, so he will have power to dissolve. He will just have power to dissolve under Indian Independence Act of 1947. Moreover, it was mentioned, it was said that the representation of states and the the tribal areas will not be decided, will not be made by the Governor General, as it is not his domain. It will be done by the Constituent Assembly. Subject to these conditions, the Federal Court withheld that the Constituent Convention will be called Constituent Assembly, and it will have same powers, all the powers which the Constituent Assembly had under the Indian Independence Act of 1947. So this was the answer as to this question. So let's come to the last question, very important question, in which it was asked by the Governor General that whether there exists any provision, any provision in the Constitution or rule of law uh, through which Governor General could validate those acts which were declared invalid due to lack of Governor General's assent, and it has been held in Yusuf Patel case that the Governor General could not retrospectively give assent to those acts until the time the Constituent Convention decides the validation of those laws. So, as to this question, Justice Munir gave again a detailed view, and he used the famous doctrine for the first time in the history of Pakistan. That was the doctrine of necessity. And Justice Munir said that the situation which was put before us in the Yusuf Patel case is totally different from the situation which is put before us now. He said that in Yusuf Patel case, the Governor General, using the powers under Section 42 of Government of India Act 1935, he assumed the powers to give assent, and he assumed the permanent powers to do legislation that was contrary to the Government of India Act 1935. So we declared that the Governor General was not competent to give retrospective assent nor work on legislative matters which were the pure domain of the Constituent Assembly. And now the Federal Court said the situation is different, because in reference with a question which has been put before us, now situation is different because the Governor General has not taken permanent or any power permanently to make laws or to validate laws. Rather, he has rather he has validated those acts for a limited time, for a specific time, until and unless the Constituent Convention decides the validation of those laws. So Justice Munir said that situation is totally different from the situation which was put before us in Yusuf Patel case. And then he mentioned the doctrine of necessity, the famous doctrine as put by Lord Mansfield, and he referred to the maxim that that which otherwise is not lawful, necessity makes it lawful. And further he referred certain maxim that the safety of people is the supreme law, the safety of the state is supreme law. And referring to these maxims, he said that now situation is such that if the Governor General does not take any such act, the state might the state machinery might break down, and the concept of civil necessity will come into play. The concept of state necessity will come into play, and the Governor General will have the powers, because he said that under the doctrine of state necessity, the head of state has a lot of powers, as the martial as the chief martial administrator has in the martial law. So he said that under the pretext of necessity, the Governor General is totally competent to do certain acts, even which otherwise are not lawful, because if he does not do such act, the state might break down. State will not have any. State might lead to anarchy. There will be a haphazard situation in the country if the Governor General does not take such acts. So, referring to these maxims and these principles, the Federal Court, for the first time in our history, it used the doctrine of necessity, and it said that the validation which has been done by the Governor General is lawful, is valid under the doctrine of necessity. And in this way, for the first time in our history, the doctrine of necessity was used, and this doctrine was later on many occasions used in our history, and it totally changed the constitutional situation of our country later on. Anyhow, Federal Court gave this decision, and again A.R. Cornelius wrote his dissenting note, and in his notes he as to the doctrine of necessity, which was used by the Justice Munir and put forward by Lord Diplock, the 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 the, uh, the Council for Federation and the Governor General. A.R. Cornelius said, as to this question, A.R. Cornelius mentioned that it has been clearly decided in Yusuf Patel case that the Governor General has no such power at all in any manner to validate those laws, because those laws are pure domain of the Constituent Assembly, and Governor General, neither on temporary basis nor permanently, the Governor General cannot validate those laws, and it is not there is no provision in Constitution and no rule of law applicable in this regard. And he further said that Governor General can exercise only the powers which have been vested in Section 42 of Government of India Act 1935 as to legislative matters, and he has power to stay the proceedings in courts other than federal court, and unless these questions are pending before unless it is pending before the federal court, the Constituent Assembly may work on those matters which have been put forward to this court. And this was what was held by the federal court by the dissenting in the dissenting note of the A.R. Cornelius. Anyhow, the majority view was that was of Justice Munir and other judges. So that decision came into force, and in this way, doctrine of necessity was used for the first time in our history.